So Rina is a lawyer and she's a co-founder of Adalah, which is the legal center for Arab minority rights in Israel. In her work with Adalah, she does research and advocacy before the UN, the EU and US bodies, fundraising, donor relations, financial management, outreach, writing and editing publications, and institutional development projects. Prior to working in Israel, she worked as a public defender in New York City and as a clinical supervisor for law students in the Criminal Justice Clinic of Georgetown University Law. And she was also a Shell Fellow at Yale Law twice, in 2005 and 2012. So Rina, 20 minutes. The floor is yours.
Very good. Thank you very much, and thank you for inviting me here today. And I hope that everyone has been having a good conference. Many of the themes that Natalie spoke about, themes like proliferation of human rights bodies, human rights law as not binding, as soft law, numerous openings for NGOs, you will hear throughout my presentation. I decided to expand my presentation a little bit. It's not just UN strategies. In fact, it's the international advocacy strategies of Adalah. And I'm asking 3 questions in my presentation. One, first, is why do we address the UN and the international community? Why is it so crucial now more than ever? And how do we measure success? Are we effective? Which, of course, is the hardest part. So first, I just want to tell you a little bit about what we do in Adalah as international advocacy. First, we engage with the UN. We engage with human rights treaty bodies, with special rapporteurs, with the Human Rights Council, and very newly with the UN Security Council in New York. We also do advocacy before the EU in Brussels, and in EU member states and in capitals. We also do work in the United States. In the past, before the Trump administration, it was mostly with the US State Department. Now, in fact, in the United States, we've adopted another model, which we call a community advocacy model, which I will not speak about here today. And then lastly, and locally, we engage very much with embassies and with consulates, and of course with the international media. So all of this big package for Adalah is our international advocacy work. So now for the first question, why do we address the UN and the international community? So our main reason, of course, for doing that is that we're seeking to influence the internationals in order to influence the internal politics in Israel, the internal politics as well as the domestic Israeli law. And as all of you well know, in general, Israeli law and politics are very hostile to the rights of Palestinian citizens and very hostile to the human rights of Palestinians living under occupation. And thus we try to put pressure on the international community, which in part is more favorable to Palestinian human rights, to compel Israel to cease some of its human rights violations. We also engage in the international system in order to make law. So yes, we're making soft law, not hard law, like from courts. And this soft law, of course, is not binding law. But over the years, we have to say that there has been an accumulation of soft law. And for us, we think this is very meaningful and shows some impact and shows some effectiveness. We're building up positive statements. We're building up favorable concluding observations from the treaty bodies and the like. And we're trying to use that in all different forums as a counterbalance to Israeli domestic law and politics. Further, we also go to the internationals because we see that by doing so, that it really empowers the Palestinian community here and in the occupied territories in order to fight for their rights. And to believe that they are right in their struggle for rights. So for example, Adalah represented the people in Imel Haran. It's a Bedouin community in the Negev, in the Nakab. We represented the people there for about 15 years in order to stay in their homes, not to be displaced, not to be dispossessed from their land. And we tried to bring a lot of international attention, both in all of these international forums and in the international media, to their plight and to their struggle. And this really helped the people to have this steadfastness, in Arabic, this samud, in order to stay on their lands and stay in their homes, and in order to continue their fight over all of these years. Another example of this empowerment aspect is regarding our challenge now to the Jewish nation-state law. And we had some initial comments of the EU regarding this law, that the EU said that the law reeks of racism, and that this law could harm Israel's international standing. The head of the EU Foreign Affairs, Federica Mogherini, said that they're very concerned that through this law that only Jews have the right to self-determination, and that this law would complicate the two-state solution. And these kinds of comments really empower the Arab-Palestinian political leadership here in their position and how they articulate their claims concerning Arab citizens here. So for all of these reasons, we're going to the international community. The second issue is, why is it more important now than ever before? So again, as you well know, there have been many changes in the Israeli Supreme Court. Ayelet Shaked has made sure of that. And with these changes, the court has become more and more conservative. And also in the Knesset, over the last 10 years of the Netanyahu government, the Knesset has become the most activist forum against Palestinian rights and the rights of Palestinian citizens of Israel. So to a great degree, a forum that is left for Palestinian citizens and Palestinians in the occupied territories is international advocacy. These forums are still left, they're still available. Now you might say, of course, there has also been a major deterioration internationally in the status of human rights and in the rise of right-wing populism, but still, and especially within the UN, you have UN expert committees, UN expert special rapporteurs who hear you and often give positive reinforcement and articulation to rights claims that we make, that the rights claims are right and valid. Now the third question regarding impact and effectiveness, in discussing this third question, I want to talk about two main strategies that Adalah uses in its international work. Very broadly, two main broad strategies. So one of these strategies is basically the UN in the EU and the EU in the UN. This linking. So we do a lot of work before the UN, and then we feed those positive statements and positive concluding observations in our work before the EU. And we feed the positive statements of the EU in the work before the UN. And then we take all of this, all of these UN positive concluding observations, positive EU statements, and we bring it before Israeli courts. Now, again, back to our petition against the Jewish nation-state law, we cited many, many concluding observations from the UN Human Rights Treaty bodies in our petition before the court. And these concluding observations, again, this concept of accumulation that we obtained over many years from the Committee Against the Elimination of Racial Discrimination, from the Committee on Economic and Social Rights, and we particularly used a lot of those comments in our challenge against Article 7 of the law, which would be of interest to Sandy, about Jewish settlement as a national value, and that the state will support and encourage and consolidate Jewish settlement. So we had a lot of concluding observations over the years that praised the decision in Kadan, for example, of the Israeli Supreme Court. We had concluding observations that spoke out against discrimination in housing, that objected to the outsourcing of discrimination by the Israeli government to the Keren Kayemet, to the Jewish National Fund, to the World Zionist Organization. Now, of course, this petition is still pending, and we have to see how this plays out before the Israeli court, but we used a lot of those concluding observations that we obtained over the years. We also did a lot of work in another case, in another series of cases that we're bringing that also concerns the Committee Against Torture. Adalah, in the past couple of years, and we never ever thought that we would be in this situation, but we're representing many cases where the state is refusing to release the bodies of Palestinians, both Palestinian citizens of Israel and Palestinians in the occupied territories. These are individuals who were alleged to have been involved in different terror attacks, and were then killed by the Israeli police or different Israeli security forces, and then the state of Israel is holding the bodies and refusing to release the bodies for burial. So we brought these issues before the CAD committee about the refusal to release the bodies when Israel was reviewed by the committee in 2016. And we targeted this issue in our shadow reports and NGO briefings with the Secretariat for the committee, with members of the committee. And we saw really that the committee was very affected by this issue of holding the bodies. And to such a degree that in fact the Israeli delegation at the committee responded to the committee that it would be releasing the bodies. Because I guess that the Israeli committee felt also in this international stage that this was a really outrageous thing to do, which they don't feel in Israel, but the delegation definitely felt that internationally. And they said that they would release the bodies. The state did release many bodies at that point after the session. And we got very good concluding observations from the Committee Against Torture about holding the bodies, and different comments about how such acts violate the dignity of the deceased and the rights of the family to a dignified burial. And then we used those comments again before the Israeli Supreme Court in the cases. And in this instant, the Supreme Court did cite the CAT committee's remarks and did cite the fact that the Israeli delegation promised to release the bodies. So those are two different examples. Another major strategy, so the first strategy is in the UN to the EU, in the UN to the EU, and all of this before the Israeli courts. A second major strategy that we've been using is we call it linking and crossover. And here our argument is that the State of Israel is pursuing the same or similar policies on both sides of the Green Line regarding Palestinian citizens of Israel and Palestinians in the occupied territories. Here, one of our main examples is what we consider to be the state's policy of forced transfer and dispossession and displacement of the Bedouins in Area C and the Bedouins in the Negev. We use this concept of crossover and linking extensively in our fight against the Proverb Plan, which was eventually frozen by the government. That legislation was eventually frozen. And again, we used that kind of strategy in order to gain more international attention to the case of El Haran. And there we were citing parallels to the cases of Sosia and Khan al-Ahmar. Now, one of the reasons that we're pursuing this linking and crossover strategy, this is with the Green Line and the occupied territories, is that, of course, as you know, many states in the world are very reluctant to appear as intervening in internal matters of Israel. So if it's happening to the Bedouin in Israel, nobody wants to talk about it. But if it's happening to the Bedouin in Area C, then everybody wants to talk about it. And so, of course, we want everybody to also talk about what's going on in the Nakab. Today, of course, things are changing about this major reluctance to interfere in internal matters, and that the international community, to some degree, is becoming more receptive to our linkages. So what we're doing also is we're bringing diplomats and journalists on tours that start in the South Hebron Hills, and then we cross the Green Line with them into the Negev to show them the parallels directly. The UN has also made this link, and the EU Parliament has made this link. The UN Special Rapporteur, even back 6 years ago, in 2012, she noted during her visit here, Adalah was of course very involved in her visit, she said, "Throughout my visit I was able to witness a land development model that excludes, discriminates against, and displaces minorities in Israel, which she says is being replicated in the occupied territories, affecting Palestinian communities, the Bedouins in the Negev in Israel, as well as the new Jewish settlements in Area C of the West Bank and inside Palestinian neighborhoods in East Jerusalem are the new frontiers of dispossession of traditional inhabitants." The EU Parliament in the same year passed a resolution that strongly condemned Israeli policies in the West Bank and East Jerusalem, including forced displacement and home demolition, and also for the first time included those kinds of policies against Arab Bedouin citizens in the Negev. In the course of that resolution, they also called on Israel to withdraw the Prover Plan. And then the Parliament just now in 2018, in a resolution against the demolition of Khan al-Ahmar, also made the link, and it called on the Israeli government to put in an immediate end to its policies and threats of demolition and actual eviction against the Bedouin communities living in the Negev and Area C. Now you could also say that there's some kind of a dynamic of this crossover, because now, of course, the Israeli government is also, very explicit and blatant in trying to show that there's no difference between the Green Line, within the Green Line, and within the West Bank. And of course, this is shown in the Jewish nation-state law, where there are no borders. And thus, the Israeli government, in fact, is inviting intervention internally by showing that, in fact, there's no border. So what we have is we have these favorable texts, as I read to you, and some favorable concluding observations, but it's still, of course, very difficult to measure success, because it's very much based on an ad hoc cases. We do need to see it over the years. With the Prover Plan, we did see that all this international work was picked up by local activist movements, which in turn organized demonstrations around the world against the Prover Plan. So there were demonstrations locally, of course, against the Prover Plan by the people in the Negev, and there were also demonstrations against the plan in Gaza and New York. And there was really intense mobilization to stop the plan, which we also think is very important to showing this impact and success. With the CAT Committee, we worked deeply with the CAT Committee about the state's refusal to release the bodies, and we saw something positive in the Israeli Supreme Court decision, where the state said it, in fact, had no legal authority of the state to hold the bodies. And finally, we think that it's very important for the lawyers of Adalah, public interest lawyers, cause lawyers, to be able to put all of these favorable texts in the petitions before the Supreme Court. While the Supreme Court will rarely rely on this soft law, still we're showing the court that the international community supports our claims, and it gives very strong legitimacy for the lawyers to stand, strongly and proudly before the Supreme Court in order to fight for these positions and to fight for these rights. Thank you very much.